Are you basing your arguments on the basis of news reports in the constitutional court before the full court?
We don't have the...
You can't articulate the same thing yourself. As senior counsel, you have to rely on a news item, which may or may not be true.
My Lord, very respectfully submitted. We don't have the record of the proceedings of the Parliament, my Lord. A question arose in certain proceedings before this honorable court in another case, and I think we submitted him even on the last day.
Please don't travel outside the domain of this court. If you wanted something, the record of the Parliament, did you write to the Speaker? Whether he would allow your request or not is a separate thing.
Lord, it's not
did
me.
You write to the Speaker?
No, my Lord, it's not me. As a matter of fact, we requested your lordships to...
I'm asking you a simple question. You didn't write to the Speaker.
My Lord,
we are a separate constitutional body. Parliament is a separate constitutional body. If you want some information from the Supreme Court, for instance, would you write to the National Speaker? You would write to the Registrar of this court. Similarly, if you want some information from the Supreme Court, Parliament, whether they give it or not would be a separate matter. Freedom of Information Act 19A has now become part of the Constitution. If you don't bother to say, avail of this opportunity, please don't take this ground before us. Because it's a hollow ground. You haven't built on the ground yet.
Lord, certain records which are publicly available, and there is no reason to doubt them. So I think at times we have been referring these some of the news items for the purpose of understanding as to how certain acts or certain legal proceedings were taken. My Lord,
please, we will hear you, but we will not hear arguments of this nature. When you say, I will not write a simple letter and I will take up the time of the entire Supreme Court to articulate a proposition which has no factual basis.
One thing
so please argue your own case. Forget what the newspapers say. You argue your case.
My Lord, this is not my case. It's not an individual's case. This is case of the whole nation, as a matter of fact, which is before your lordships. So therefore, certain items...
Please, again you have assumed yourself. Azur, you have assumed yourself the representative of the nation. Sorry, you are not. You are a petitioner before us. Argue your case.
My Lord,
we don't assume to speak for the nation, nor can you speak for the nation.
My Lord, 184.3 proceedings, as a matter of fact, are meant for two important things. One, matter of public importance, and then breach of fundamental rights, that matter, and its enforcement. So this is, I must say, this is relevant in any case at par. If you just permit me just one line, because it's very relevant. Ex-Prime Minister wants National Assembly to summon CJP, Chief Justice of Pakistan. I must say, very respectfully, this...
Please do not say anything. That list is not before us. And you've not made the person a party. You cannot make allegations against somebody without making him a party or her a party. Please, we will not permit this.
Right, my Lord.
You can't use this forum as for a political debate. The media is available to you. You can go and give a talk on the media.
Lord, I am before your lordships on law and constitution. So therefore, my respectful submission is certain relevant facts which are admitted and publicly known. They are relevant because the proceedings
Please tell us what are those.
Many years ki, now your lordship may permit me, we had an assembly of lot of people right out on the Constitution Avenue. This is a background, my lord, in which this enactment was being passed by the assembly, and they had encroached upon the area which is within the ambit of your lordship, that is the judiciary. So that is why
ये point argue कीजिए ना कि पार्लियामान ने सुप्रीम कोर्ट के इख्तियारात सलब किए, ये कानूनी दलाइल दीजिए ना.
मैं इसलिए ये अर्ज कर रहा था कि ये बातें, ये सारे फैक्ट्स जो हैं, इसके अंदर ये कानून साजी की गई, इसीलिए बात चीज़ें रिलेट करना या आपके साथ रखना, लेकिन क्योंकि आप फरमाते हैं कि नहीं, ऐसा नहीं होना चाहिए, सो
चलिए ठीक है, कानूनी बात कीजिए.
मैं ये गुजारिश करना चाहूँगा कि ये केस जो बुनियादी तौर पे आपके सामने है, इसमें जो सवाल उठाए गए थे मुख्तलिफ, उसमें ये था कि ये बिल क्या ये इसको टेकअप किया जा सकता था 184(3) में। पहले तो मेंटेनेबिलिटी की बात थी, तो मैं ये गुजारिश करना कि ये एक्ट इटसेल्फ, ये जो इसकी बिगिनिंग है, ये जाहिर कर रही है कि ये फंडामेंटल राइट्स के हवाले से ये इनेक्टमेंट की जा रही है। सो वी क्वेश्चन दिस इनेक्टमेंट ऑन दैट बेसिस। Maintainability definitely is there because it's a matter of public importance relating to the fundamental rights. Regarding the bill, my lord, there was a question as to whether a bill could have been brought before this honorable court for the purposes of adjudication under Article 184(3) at the time when it was not the act passed by the parliament. I'll be just referring to HISBA bill, which was PLD 2005 Supreme Court 873. Elaborate, Lord, this bill has been discussed.
Chaudhary Sahab, if I may interject at this juncture. हस्बा बिल का जो केस था, इस केस से ज़रा इसलिए फ़र्क है क्योंकि ये बिल अब कानून बन चुका है, ठीक है। अब वो पहले फाइल हुई पिटिशन या बाद में फाइल हुई, वो एक हद तक एक डिबेट का पहलू रखती है, क्योंकि अब ये कानून बन गया एक्ट पार्लियामेंट, तो ये इस पॉइंट को रहने दीजिए। हस्बा बिल में वो कानून कभी बना ही नहीं था, ठीक है। तो अगर हम आपकी ये बात मान भी लें, क्योंकि अब वो कहते हैं ना अंग्रेजी में वाटर इज फ्लोन ऑन द ब्रिज, अब ये एक्ट बन गया है, ठीक है। तो वो कर सकते थे या नहीं कर सकते थे, उस बहस में जाने के लिए हमें अभी ज़रूरत शायद पेश ना आए, क्योंकि अब एक्ट बन गया। अगर तो एक्ट बना ही नहीं होता, फिर आप ये बहस कर सकते थे कि जी ये बनना ही नहीं चाहिए, क्योंकि बन है तो बस आ गया। अब यहाँ से बढ़ाते हैं ना बात को, क्योंकि अब फिर भी अगर सपोज हमने टेक्निकली हम आपसे ऐसी फॉर द सेक ऑफ आर्गुमेंट अग्री करें या ना अग्री करें, मगर वो बात तो अपनी जगह ठहरेगी ना कि ये जो कानून है ये आइन के मुताबिक है या आइन से तसादुम रखता है। ये बात असल सवाल है, इधर आप फोकस कीजिए।
मैं उसी तरफ
नहीं, आपकी मान ली बात, वो चले मान भी लेते हैं, हम उस पर बहस में जाते ही नहीं। आप निकाह के आ सकते हैं, चले आ गए आप, मगर सवाल तो वहीं खड़ा रहेगा ना फिर भी। हाँ,
अब मेंटेनेबिलिटी और इसके हवाले से मैंने गुजारिश कर ली माय लॉर्ड। मैं ये अर्ज करना चाहूँगा कि ये जो हम आपके सामने है इनेक्टमेंट, जैसे मैंने अर्ज की कि इसकी सेक्शन मुख्तलिफ जो यहाँ इनेक्ट हुई, ये एनक्रोच हुई the area which is within the jurisdiction of this honorable court. So trichotomy जो है, that is been, as a matter of fact, negated. This enactment, I would say that totally denies the constitution itself. Very respectfully I'll submit. Because when one of the state, that is out of the three, the executive, parliament and the judiciary, when the judiciary is being somehow, as I said, very respectfully, when it will be bulldozed by enactment, which is on record on the statute book at the moment, I must say the very law would be wide and unconstitutional, and would have jurisdiction to look into its constitutionality, because at times it is said, and certain objections are raised, that the constitutional amendments may be not agitatable before the Honorable Supreme Court. My submission is definitely when there is a wide law, unconstitutional, very fundamentally, it would be within the authority of this August court to look into it and to declare ultra vires or otherwise. So I'll be just for your, ये दे दीजिए।